All right, we are live. Hi, everyone. My name is Michelangelo Mortellaro with Mortellaro Law, and I'm here today with Grace from Sunset Villas. Grace, tell us a little bit about your community. Part of this is we're hosting today for you guys and for your prospective residents, but for those people who are joined in and watching this that don't know about your community, tell us a little bit about the community and your role there.
Thank you, Michelangelo. Hi, everybody. My name is Grace Gentry. I'm the Director of Sales and Marketing here at the Villas at Sunset Bay. We're in Newport Richey. We have 52 apartments. We are the only freestanding assisted living that's dedicated solely to memory care here in the Newport Richey area. So that means all of our staff, our caregivers, our support team are all trained and dedicated purposefully for folks with varying levels of memory impairment. We have, we've been in operation, I believe, since 2003. We're managed by Elegance. That's our parent company based out of Baltimore, Maryland. And we are, we have a lot of fun here. We have a chef who's been with us over 2 years, very dedicated to providing special preferences for each of our residents. We are able to provide special diets. So if you have questions about can we accommodate a certain type of diet like a mechanical soft or a thickened liquid, I could answer those questions at a later time, but we do accommodate most special diets. We are a standard license assisted living, and we do advocate for hospice services. So hospices are definitely welcome at the Villas at Sunset Bay, and we've had really great relationships with the Pasco County hospice organizations. That's what it. We do have availability. We have semi-private and private apartments, and we're offering some great Happy New Year specials right now.
Okay. What are you guys, how are you doing now with COVID? What precautions are you guys taking? I know there's been a bit of ebb and flow in precautions at the community level. What are you guys doing to keep people safe?
Yeah, so we have been very fortunate here at the Villas at Sunset Bay. We have not had any positive cases with residents or employees. So we're very grateful for that. We do have limited visitation. We have allowed, we've had different options for visits, and I think that's kind of what kept a lot of our folks safe from getting the virus. We did not allow in-person visits for quite some time, up until about a month ago. We do allow, we have window visits where the family or the guest can sit outside of a designated window and speak on the phone with their loved one. We have video chats that are available that can be scheduled through our front desk. The in-person visits, everyone is required to be screened with the temperature screening and the COVID questionnaire before they're allowed to enter. We don't allow a lot of people in the building unless they are here for a scheduled visit and they've passed the screening, or if they work here, or if they are a support staff, for instance, home health, hospice worker, lab worker, those kinds of things. So we've kept the visitors to a minimum. We do have, we're on a weekly testing mandatory, so everybody that's employed here or lives here gets a weekly COVID test. And I think we are in our 5th week of the weekly tests, and we have not had any positive cases. So we're moving forward. And then we are scheduled to get our first wave of vaccine on January 31st. 100% of our residents will be getting the first vaccine on January 31st. CVS is coming in to administer the vaccines. And I believe we're still recruiting. We're not mandating it for employees, but we're incentivizing our employees to get the vaccine as well. So those numbers hopefully will rise up even more before the first round.
That's good. I've been talking with some people in the pharmaceutical industry, and they've relayed to me that even though people might be apprehensive of moving their loved one into a community with respect to the vaccines, I think the communities are getting access to the vaccines faster than a similarly aged individual out in the community. So that could be a good thing, and ultimately keeping our seniors safe is great. And congratulations to your community for taking whatever precautions it needed to keep everyone safe so far, and hopefully with the vaccine on the horizon that will continue. So today's topic is several, all interrelated. And so we're going to talk about some estate planning topics that seniors and their families need to be thinking about. And then ultimately, we're going to transition the discussion into how to pay for senior living and what options are available. And if anyone out there has not looked into senior living, sometimes they are surprised at the cost of care. And I tell them, it may be more than you were anticipating, but the reality is, if you think about the facilities involved and the employees and all of the administrative stuff to keep everyone, whether it's a secure memory care facility, make sure they stay safe and stay within the boundaries that they're designated. All of that you can't do inexpensively. So quite often people are trying to figure out other resources that can help pay for themselves or their loved ones in a senior community. So starting off the conversation with general estate planning, there are a few documents that everyone should have as an adult, but certainly the older we get, the more these documents become important and more likely to be used. And specifically, three major documents: the durable power of attorney, the healthcare surrogate, and the living will. Those are kind of the holy trinity, if you will, of estate planning documents, certainly for seniors. And really, those documents are designed to address times of disability or incapacity. And because you are a dedicated memory care unit, or at least the majority of your residents there are dealing with some cognitive challenges, these documents were designed for that group. And the idea is that if at some point you lose capacity to make your own decisions, it's really important that everyone take the time to designate agents or people that they trust to be able to step into their shoes and make these legal, financial, and medical decisions. We'll talk a little bit more about the documents individually. The durable power of attorney is your legal and financial document. And not all durable powers of attorney are created equally. I just reviewed one today out of Colorado. The entire document fit on one page with the signatures on the second page. And I was somewhat surprised that it was that brief of a document for something that really needs to address so many topics. In Florida, even if you have an estate planning attorney draft your power of attorney, it's most likely going to be somewhere between 5 and 11 pages in length. However, a good elder law driven power of attorney should never be less than 30 pages in length. Mine typically run somewhere between 33 and 35 pages. And people ask me, well, why does it need to be so lengthy of a document? And the answer is because we don't know what we don't know. If you lose capacity and you are unable to sign new documents, you are effectively stuck with whatever you have in place. So why not take the steps to stick yourself, if that's the answer, get stuck with, I should say, the best set of documents that you can get your hands on that have the most amount of flexibility, control, and opportunities for planning, rather than a bare bones minimum document that after the fact, when you can't sign new documents, your elder law attorney then says, oh boy, it really would have been nice if you had all these other provisions. Because the provisions do nothing but empower your agents to have, again, more flexibility and control over your legal and financial decisions. Part of that is asset protection. Part of that is moving money legally and legitimately to qualify for things like veterans benefits, which we'll talk about shortly. Or if you end up in a nursing home scenario and that nursing home is $12,000 a month, there are strategies that we can implement that all start inside your durable power of attorney to help shelter your income and assets and let Medicaid potentially come in and pay that nursing home bill rather than you going broke in the process. All of these strategies are legal. They've been approved by Medicaid. They've been approved by the Florida court system, but it does require that special language be in your documents in order for you to take advantage of those planning strategies. So a misconception that I like to address as I get through any misconceptions that I run across on a normal basis is that once you are diagnosed with a memory care issue, that you are instantly barred from drafting any legal documents or signing any legal documents. And that is not necessarily the case. a early stage or a preliminary diagnosis of a dementia or an Alzheimer's related illness does not automatically mean that you don't have capacity. It means that we've identified that whether it's the genetic markers or whether it's brain scans, that you are dealing with this, and it's more likely going to get worse and not better over time. But that doesn't mean that you are prohibited from executing documents. So it's a great opportunity on an initial diagnosis. As soon as you can, get your loved one to a qualified elder law attorney, have the interview. Sometimes the answer is we've already kind of crossed that bridge and we don't have the option to sign new documents. But I would say the vast majority of the time, if caught early enough, we are able to kind of brush up the documents and get them where we need. So the power of attorney is for legal and financial decision making. The durable power of attorney is what we call it in Florida. Other states often call it a medical power of attorney. And it's really kind of the same document, but it is set up to make medical decisions and to be able to get HIPAA information or private health information that otherwise individuals would not be privy to. So power of attorney, healthcare surrogate, and then living will. The living will, while not necessary, it's a good thing to have. And it is the document that directs your doctors and healthcare facilities that if you have lost capacity to make your own decisions, and the only way to keep you alive is on a machine, typically a feeding tube or a ventilator, and the doctors all agree that you're never getting stronger and coming off of the machines on your own, what would you want in that circumstance? Some people say, I prefer not to live that way. Please remove the life support, allow me to pass away. Other people say, as long as you can keep me breathing, I don't care how that works, just do it because I don't want to pass away. Whatever you decide is important to you. And my job, or the elder law attorney's job, is to make sure that gets down in a way where your family knows what you want, your physicians know what you want, and if there's ever a disagreement, we could call on a judge to interpret the document and make sure that you get what you anticipated. I rarely, if ever, see it get to the judge point because the documents are very clear and the person basically spells out what they want in that scenario. So everyone should have those. Certainly people looking at any sort of a senior living solution, and certainly anyone looking at a memory care dedicated facility should have those documents in place or be attempting at their best to get them done in the short term. If your family member has already lost capacity, that doesn't mean you're out in the woods alone. It just means that we would need to move for a legal guardianship to put a family member in charge of the incapacitated individual. It does limit the planning strategies and it limits the things we can do because now everything needs to be approved by a judge. However, it's better to have a legal guardianship than to have no documents at all when you're trying to support a family member. So moving on from the advanced directives, just very high level on estate planning in general, you should have at least a last will and testament, if not a revocable living trust. Misconception about trusts in Florida. People think if you're not a millionaire that you don't need a trust. Trust can be very effective even for individuals with a very modest estate. It is always cheaper to plan to avoid probate than to go through the process. And another misconception is people think I have a last will and testament, so I just take that to the bank, or my children or my spouse takes that to the bank when I pass away, and they're handed the money. That is not the way the last will and testament works. It needs to go through the court system. A judge needs to approve it. And then there's a whole process, typically 6 to 12 months to get through that probate process. The revocable living trust provides efficiency, whereas you can just take the document down to the bank and they will accept it without a court order and without you having to pay attorney's fees and court costs and publication fees and bond and paralegal fees just to get your stuff to your beneficiaries. So again, as part of the conversation with the elder law attorney on the advanced directives, should also be a conversation about, is a will or a trust appropriate in the situation? So from there, I want to switch gears a little bit to paying for senior living. There are several options. The most obvious is self-pay. So if you're blessed to have a strong Social Security payment, maybe a pension or two, there are people that can self-sustain or get pretty close to it to pay their own way through their senior living requirements. That being said, there are oftentimes, and I would say the average senior over 65 person in the US doesn't make enough to pay for a good quality assisted living, or certainly a memory care facility. They tend to cost a little bit more at times than a traditional assisted living. And so we're always kind of playing that time to broke analysis. So we look at, how much do you make? What's your facility going to cost? What do you have in the bank? What other resources do you have? Sometimes people own their home and there's no debt on it. And if they're going to permanently move into a facility and never go back home, then that's a great opportunity to sell the house or turn it into a rental, to be able to pull extra income or equity from that in order to help fund the facility. Sometimes people don't have a home, or they have a big mortgage on it. So we can look at things like IRAs. We can look at things like cash value from life insurance. Certainly failed to mention, but I should, that if you are lucky enough to have long-term care insurance, that is something that can often help pay some or all of your senior living. And those are great to have. Unfortunately, if you don't already have them, by the time you're in need for a facility, it's kind of like trying to buy homeowners insurance while the roof is on fire. Typically not an option. So you need to set those up ahead of time. If anyone is watching this or watching the replay and is a child of a senior, their parent who they're watching this for, take the opportunity to have a conversation with your own financial advisor or insurance professional. And it may be too late to buy long-term care insurance for mom or dad, but if you're in your 40s, 50s, 60s, there still may be a great opportunity for you to purchase that for yourself, so that maybe your children in the future aren't scrambling to figure out the finances as much as you may be doing for your parents. One of the great ways for those that qualify to help pay for senior care is the Veterans Benefit, often known as aid and attendance. The reality is most veterans and the vast majority of widows of veterans have never heard of this benefit. It is not advertised. If you go to the VA for your health care, I promise you in the waiting room, you're not going to see a big billboard that says, hey, if you're a wartime veteran, you might be eligible for cash to help you pay for your assisted living or memory care facility. They don't advertise it. I think I know why, but I wish they did. I think if everybody who was eligible applied at one time, it would crash their system. So they try to keep the details under wraps. Certainly, if you call the VA and start asking questions about this benefit, in my experience, the employees are woefully undertrained and they don't have the expertise on how the benefit works, how to get qualified for it in an efficient manner. And so often people that try to do it on their own will 2 to 3 years in process of trying to get the benefit before they're ever able to get it turned on. So what a VA accredited elder law attorney brings to the table is efficiency. Often for our clients, we are getting these applications approved in 60 to 90, 60 to 120 days versus 2 to 3 years. And that can make a big difference if you are spending more than you make each month at your community and you have a limited number of months until you go broke and potentially have to move out of the community. Getting that VA benefit turned on as soon as possible can be imperative. And that's what the value of a VA attorney can do for you. Also, the VA attorney has the option in his or her kind of toolkit to implement approved and well-known strategies to allow individual claimants that either make too much money or have too much in assets. We can allow those individuals to go ahead and qualify for the benefit before they could organically on their own. If you just show up at the VA with all of your bank statements and they say, oh, you have too much in the bank, what they will tell you is, well, spend it down to this point and then come back and see us. What the elder law attorney can do in the VA world is legally and legitimately shelter that excess assets, the excess income, in order to get you qualified now versus after you've spent down whatever your required spend down would be. So you don't need us, but sometimes you want us for our expertise and our efficiency. I do 15 to 25 VA applications a week out of my office. We've done thousands of them without a denial, and it works really well. We know what the VA is going to ask before they ask it. And so often our submissions, while the application is only about 9 to 12 pages, our submissions are often up to 200 pages of supporting documents, because we already know what the VA will ask you in response to your application. And each time the VA has to ask you a question that you have to respond to, even if you respond the same day, it's likely going to take 90 to 120 days before the VA even reads your response. And then they ask you the next question, and then you respond, and then it's another 3 to 4 months, and they will just 3 to 4 month question you, sometimes to death, certainly to an inefficient result. So we know all the things they can ask. We give them all to them at one time, and it basically cuts off the cat and mouse game of them continuing to ask questions and us having to then go back and submit responses, which then take more time. So let's talk generally about the benefit. What does it offer? Well, the benefit is a cash benefit, and it is paid direct deposit right into your bank account, just like Social Security or a pension would be. A really good thing about this benefit also is it's tax-free, so you're not paying income taxes on the benefit. The numbers have just gone up now for January of 21, and I have them here. There are 3 levels of benefit as far as how much you get paid, and it depends on your status. If you are a married veteran, then you get the highest amount. And for 2021, that is now $2,295 per month. If you are a single veteran, you are entitled for up to $1,936 per month. And if you are a surviving spouse of a veteran, you are entitled to up to $1,244. I use the terms up to because it is not a light switch where you get all or nothing. One of the things that we're very good at, and we have a perfect track record at, is getting our clients the maximum benefit. Sometimes if you don't understand the rules and you don't have the strategies available to you to legally manipulate your income and expenses, then the VA may say, oh, well, you're only going to get $200 a month instead of $2,295. What we are able to do for our clients is make sure that they can always get the maximum amount. And if there's a reason you're not going to get the maximum amount, we'll know that, and we'll explain to you this is the most you're probably going to get until and unless your situation changes and your expenses go up. So that's what it pays. High-level eligibility. There's a bunch of misconceptions here. It is called technically a non-service connected disability pension. And when people hear the word pension, I think they typically think, well, in order to get a pension, you normally have to work somewhere for a long time. Well, the reality is for this pension, you only had to be active duty in the US military for 90 consecutive days. So I don't know of anyone that organically would think, well, after 90 days of employment, I'm eligible for some sort of pension. In the civilian world, that doesn't happen. But in the military world, 90 days of active duty service, you can qualify for this pension. The other piece of that military service that's important is that at least one of your 90 days needed to have been during a recognized war period. You did not have to be in the war zone. So another misconception is, well, I served during Korea or Vietnam era, but I never was deployed. I was stateside. I was administrative. I never left the base. That doesn't matter. This is not a combat veteran pension. This is a wartime veteran pension. So I tell people all the time, you could have been stationed in Hawaii, during Vietnam, sitting under a coconut tree, sipping on a pina colada, but you're active duty in the military, and so therefore you qualify. You did not have to be in the war zone. You didn't have to be in combat. So that's important. You need to have a better than dishonorable discharge. That one's relatively straightforward. The vast majority of our veterans do get discharged with a greater than dishonorable. It can be general, it can be medical, certainly can be honorable, which most of them are. If you have a dishonorable discharge, unfortunately, this benefit would not be, you would not be eligible for this benefit. The next piece is age 65 or older, which most of our folks looking at senior communities already meet that criteria. But for memory care, there are people with early onset dementia. They could be under age 65 and still need benefits. There is a caveat in the rules that allow for someone under age 65, if you are permanently and totally disabled, but not through a service-connected disability, dementia and Alzheimer's would qualify for that. So there's a possibility if you're under age 65, we could still get the benefit. That would lend itself to a conversation with the elder law attorney. That's the qualifications for the veteran. Now, if we have a surviving spouse of a veteran, we have a few extra questions. First, a misconception. Often widows of veterans will say, well, I wasn't married to the veteran during his or her service. You know, we got married years after they got out of the military. So, you know, I guess I don't qualify. That is not the case. As long as you were married to the veteran for at least 1 year before the veteran died, did not have to be, during their service, 1 year before they died, and you have not remarried since their death, then you can qualify. So those are the extra questions we have to ask for a widow. Were you married for at least 1 year before the death? Obviously, at the death, occasionally I get the question, well, you know, what if we got divorced? Typically, a divorce will cut off this benefit because at that point, you're not a surviving spouse, you're a surviving ex-spouse. There are a few exceptions to that rule. I'm happy to have that conversation, but generally speaking, a run-of-the-mill divorce will cut off the benefits. If the spouse gets remarried, then they would also not be eligible unless they remarried another qualifying veteran who also passed away. Sometimes that happens. But I occasionally get the question, well, my first husband was a wartime veteran. He passed away. I then married another gentleman who was a veteran, but not a wartime veteran. Can I go back to my first husband's wartime service and still get the benefit? The answer is no. It has to be the most recent spouse, and they have to be a qualified veteran for you to qualify for the benefit as a surviving spouse. All right, so that is high level. And again, this is not a dissertation on all the rules. This is cramming a lot of information into a short time just to educate people on the fact this benefit's available. And if they are intrigued with it and they'd like a consultation, at least at my firm, we don't charge for consultation. So we're happy to sit with the family, talk with them, flesh out the details. And if it's something that you're eligible for, we'll let you know that you're eligible. And if some planning and strategy steps need to be taken prior to eligibility, we can also share that information with you during the consultation. So we've gone over so far what it pays. We've gone over how to qualify as a veteran or a widow. Next, we're going to be talking about income and asset restrictions. So unlike Medicaid, which we'll talk briefly about in a nursing home context later, unlike Medicaid that has stringent to the penny income requirements or limits, I should say, the VA is a slide scale. And many of times I consult with families and they say, you know, we heard about this benefit. We went down to the VA, and the first question they asked us when we asked about eligibility, they asked us, how much do you make in income? When we told them how much we make in income, they just said, you make too much, you don't qualify. That is an incomplete answer. It's not how much you make. It is it's a calculation of how much do you make in income, and it's gross monthly household income. So if you're married, it's both spouses. If you're not married, it's the single individual's income, but it's gross monthly household income. And then we look at your, as the VA calls them, UMEs, or unreimbursed medical expenses. And unreimbursed medical expenses can come in a variety of flavors. If you are home and you are paying for private duty, whether it's companion care or private nursing care, anything where someone's coming into your home to help you with activities of daily living, things like bathing, dressing, toileting, medication management, meal preparation, housekeeping, transportation. If you are paying for those services to come into your home, that is an unreimbursed medical expense. If you move into an assisted living or a memory care facility, then typically the entire bill is considered an unreimbursed medical expense. And so for the majority of seniors, as I mentioned earlier, their facility is going to cost them every bit, if not more, than what they make in income. So what the VA is really looking for is what they call a negative IVAP, or income for VA purposes. And again, it's just that simple calculation of how much do you make and how much are you spending on care. If you're spending more on care than what you make in income, then you are negative. And by being negative, that's when the VA gives you the maximum benefit. So for our clients, we always make sure that one way or another, we get their expenses to overshadow their income so that they are negative, and that way they get the maximum benefit. And sometimes that's as simple as going to the community and saying, listen, we have a couple extra income dollars, but maybe mom could use a little extra care, or maybe we want to take mom to the next level of care where we're doing things for her now that she's probably going to need in the short term. So we can go ahead and prepay for some services in order to get us over that threshold and allow VA to pay the maximum. For my family members that are in a facility and they have local family, and that family is coming to visit them, maybe COVID notwithstanding, take them out for a meal or take them to the doctor, or just bring them home for the afternoon or for Sunday dinner. Those are all things that in a non-COVID period sometimes happen in assisted livings and memory cares. We can privately contract with those family members, and we can pay them for their time to spend with their own parents in order to create unreimbursed medical expenses to get us over the negative IVAP hump. So many strategies to do that. That's just one of them. Know that they're there, and know that if you want the maximum benefit, you have to show the VA that you're spending more than you're making. Typically not that difficult. So for those folks that go to the VA and are just told you make too much money without anyone asking the question, how much are you spending on care? Then I think it's a poor answer, and it's an incorrect answer from the VA. And then these poor seniors take that as gospel. They go home and say, well, I make too much money, I'm not going to look into it. It's probably not the case. I'll give you a quick example. I had a gentleman, he and his wife were both retired military. They retired early as far as they were young. They then went out and both got civil service jobs that they then retired from. And so they were getting their Social Security and 2 pensions, and they were bringing in over $9,000 a month in retirement income. And that is practically unheard of. In my 6,000 clients, I believe they are making the most that I've ever seen. So the husband realizes that he and his wife are needing care, and they're already privately paying for care, which I'll get to in a moment. They went down to the VA, and the VA says, how much do you make? Oh, $9,000 a month. And they literally laughed him right out and said, you're out of your mind. You make way too much money. You're never going to get this benefit. If they would have asked the second question, they would have realized that this veteran and his veteran wife were paying for 24/7 home care. They were paying $16,000 a month to effectively have someone as a private caregiver live with them 24/7. And if the VA would have asked the second question, even though $9,000 is a big number per month, if they would have realized that they're paying 16 and making 9, well, that's the same as someone making $900 a month on Social Security and paying $1,000 a month for home care. Doesn't matter. So it's not what you make, it's what you spend, and it's that combination of the two. So I was able to get this gentleman benefits after the VA told him there's no way you'll ever get it. You make too much money. Consult with someone who does this for a living, who preferably doesn't work for the VA. You're more likely to get a better solid answer that will maybe be the difference between you getting the benefit and not getting it. Now let's talk about assets. The rules changed for VA asset analysis back on October 18th of 2018. Prior to that date, I could take anyone with any amount of assets, and I had several multi-million-dollar clients that I was able to draft a irrevocable trust, a Veterans Asset Protection Trust specifically. I could take that money, shove it in that trust, the next day apply for benefits, and the VA would then say, you qualify because you're under the asset threshold. Now, the asset threshold for this year is right around $129,000. In fact, that number may have gone up now in January. I don't have the new number yet, but for last year it was $129,094. So somewhere around the $130,000 mark. Now, that's available assets or countable assets. They do not count your home and they do not count your vehicles. So we take those out of the equation, and many people at that point qualify if they take your home and your vehicles out. Now, the VA also does count your IRAs. They do count cash value of life insurance policy, cash value of annuities. Those are all things that we need to contemplate. And again, the post 2018 rules made things a little more difficult because I now can't do something as simple as draft a trust, shove the assets in the trust, and apply for VA the next day. However, over the last 2 years and change, we have developed pretty good strategies that are still able to legally and legitimately reduce your assets on paper without delaying the benefit or without causing a penalty. So that's something that if you have more than 130,000 in countable assets, have a conversation. Don't just say, well, I have to spend it all down. The answer is you probably don't. Also, if you own a home and you are thinking about moving into a community full-time and you're never going to go back and live in that home again, for some people, they would prefer to sell it. Well, the VA loves when you sell your home because you took a non-countable exempt asset and you just turned it into cash. Cash is always countable. And so now the VA says, oh, well, before you sold your house, you had only $120,000 in assets, but you just sold your house for 200 and you had no mortgage. So now you have 320, you now don't qualify. I can still use the Veterans Asset Protection Trust for that transaction. We can take the home, we can transfer it into the trust. And then once that transfer happens, we can do whatever we want within that trust and not have the value of the home countable as an asset for VA purposes. So that's another strategy. Worst case scenario, if you come to me and you have $5 million in assets, which we were also lucky, and you want this benefit, the worst case scenario is we're going to need to create the trust and then hold your application for 36 months. It's not great, but depending on your stage in life, if you have beginning stages of dementia and you are in your late 60s or early 70s, a 36-month waiting period probably isn't the end of the world. If you are a 98-year-old World War II veteran, then 3 years might be a little more challenging to get across just based on life expectancy. So it's different for everyone. The point of this is have the conversation with a VA accredited elder law attorney and make sure that you get good answers to your questions and a good analysis of your specific factual situation. I would caution individuals, if you're going to seek assistance, use an attorney. There are companies out there and there are financial advisors out there who will masquerade as friends of the veterans. And really what they're trying to do most of the time is sell you financial products. It was easier for them pre-October of 2018 because they could take all of your money, drop it in an annuity with zero cash value, make a 13% commission, and then make you broke for purposes of the VA benefit. While that worked, it was never a really good idea because the annuities they were selling were not Medicaid friendly. So down the road, if you ended up in a nursing home, you very well may never be eligible, or maybe some period of time before you're eligible for Medicaid benefits to pay your nursing home bill because of the annuity you purchased. Grace, I guess I'll turn it over to you. You've kind of heard this. Any questions that you have from your perspective as working in a facility, and questions that you think your prospective residents and their families may have?
I know one question I do get quite often is, does the prospect have to be living in the assisted living community before they can apply for the VA benefit?
Good question. It's a bit of a chicken and the egg. The answer is it depends, as all good lawyer answers should start. But the rules say that you need to be spending more than you are making for income. So for most folks, yes, it would be required that they move in, pay the first month's payment, and if there's a community fee or something, and show the VA that check and the fact that it's been cashed by the community to say, listen, I make $3,000 a month between my pension and Social Security, and I just wrote a check to this place for $5,000 a month. So as you can see, I'm negative $2,000 a month. Please help me. However, in some cases, factually, I have seniors that are living with one of their children prior to moving into a community. Well, we could draft a caregiver agreement with the child for 24/7 care. I can create the unreimbursed medical expense through a private contract, a caregiver agreement with a family member, and then sometime after that contract is created, just transition the unreimbursed medical expense over to the community. Sometimes we have to do that in cases where the individual doesn't have a lot of resources to fall back on. And so during the application process, if it took 6 months, they would not be able to front the negative cash flow each month to the facility for 6 months while waiting on the VA. And it causes stress for them. It's never a good situation. So if they're living with a family member or they have a family member close by that's coming to visit them often, we can draft that contract, use the contract as the unreimbursed medical expense. Once the benefit turns on and they feel more comfortable that now they can truly afford their community, then they can move in after the fact. Did that answer your question?
Yeah. So are you saying, so if can they start the process before they move in? Even say if they say they're independent, but they're not doing well in their own home environment, and it's inevitable that they are going to move to assisted living, can they at least have a consultation with an elder?
Yeah. I mean, I love early consultations because unlike a service-connected disability pension, which means you had to be injured or exposed to some chemical substance during your service, this benefit does not go retro. It only goes retro to the first day of the month following the month of application. So weekly, I talk to families that have just learned about this benefit. They come to see me and they say, oh, mom's been in this memory care place for the last 5 years. We've been hemorrhaging money. And so can we go back and get all those months? The answer is no. It's only from the time of application. So I love talking to families and being able to tell them right now you're too healthy. And so right now you won't qualify, but I give them all of the trigger points that if X, Y, or Z happens, or if you start to see this on the horizon, come back and see me. That will be the appropriate time to move forward. But in a perfect world, you will always have a consultation for legal services before the need arises. Any other questions?
None that come to mind right now.
Okay, perfect. So the last thing I'll leave you with is we talk about Medicaid, and typically we talk about Medicaid in the world of nursing homes, because nursing homes are incredibly expensive. On average, $10,000 to $12,000 a month without therapy, and if you're getting intensive rehab therapy, I've seen them $13,000 to $18,000 a month. And if people think that $4,000 to $6,000 is a lot of money to spend on assisted living or memory care, when they see a $12,000 a month bill, it really doesn't go well. So Medicaid is a program that does offer assistance with nursing homes, and it's a great financial program, and it pays the entire nursing home bill over your income. Still lets you keep $130 a month for your personal needs allowance. So to give you an example, if you were to make right at $1,000 a month in Social Security, you have no other income, and you fall and break the hip, you have the stroke, something catastrophic that forces you into the level of care that's above what a assisted living or a memory care facility is licensed to provide you, you might need that skilled level of care. So if you have a $12,000 a month bill at your nursing home and you only make $1,000 a month, we as elder law attorneys can shelter all of your assets above the $2,000 threshold for Medicaid and allow Medicaid to kick in typically within 30 days. Now, when Medicaid kicks in, you still need to give up your income, so your $1,000 a month, of which you get to keep $130 a month. So you would then write a check to your nursing home for $870 a month, and Medicaid pays the difference between the $870 a month and the $12,000 a month. Huge benefit financially. Now, that unfortunately means you're pretty sick. And so your quality of life isn't going to be what we would all hoped for. But if you find yourself in the unfortunate situation from a medical needs standpoint, Medicaid's a home run. So you want to make sure that none of the planning and none of the money that you've moved in the past will come back and bite you for purposes of a Medicaid application. And that brings me back to my earlier discussion of using a financial advisor or someone to help you get Medicaid benefits that's going to be using financial products to try to sell you to get you qualified. Because if those financial products are not Medicaid friendly, and many of them are not, down the road, you could be shut out of Medicaid. So be careful who you work with, make sure that you vet them, their reputation, and whoever you work with, make sure that it is an attorney that is both VA accredited, if you're a veteran or a widow, and practices in the area of Medicaid. Some elder law attorneys only do one or the other. And while they may mean well, if all they're doing and their knowledge base is just getting VA, they may not be thinking in the future about Medicaid. All of my VA plans have a backdoor built-in strategies ready to go to convert their VA plan to a Medicaid plan if they ever get to the point where their community tells them, like, your level of care has gotten too high, we can't keep you, nursing home is going to be your next stop. So all of my plans have that built in. You're not paying me now for Medicaid planning, but I know that to be a good lawyer, I need to prepare you for that, so that for those clients that need it, I don't look like I don't know what I'm doing and say, oh boy, I hadn't thought of Medicaid. And I put you in a strategy that unfortunately messed up your possibility of Medicaid. So know that that's there. Any questions on Medicaid? I know not necessarily for your community, but just in general, how the benefit works and how it may work in a nursing scenario.
No, I just have some other general questions. I can wait till the end if you want.
I'm good, and I think we have about 13 minutes left on the scheduled calendar. So by all means.
So we have a lot of adult children that are in the planning stages for bringing their parent down here from out of state. So if mom has, say mom's from New York, she has all of her legal documents are in the state of New York. Are they required to convert them over to Florida power of attorney? I mean, what's the state requirement? Do they have to get a new POA, a new living will, once they move them to a new state?
Great question. The answer is no, but yes. So every state has reciprocity with every other state. As long as the document was properly executed under the laws of the state that they were drafted and executed in at the time they were drafted and executed, then Florida will accept them. So a 1972 New York power of attorney, as long as it was done properly in New York in 1972, can be used in Florida. However, Florida is arguably the best state in the country to get old and sick in, because our Medicaid rules are very relaxed and very pro-senior and allow us to do a lot of stuff like, I had a gentleman that had $5.4 million in assets. I was able to get him Medicaid for his nursing home within 45 days. Other states, you just can't do that. And so what allows me to leverage the Florida law goes back to my initial comments on power of attorney. Why do you need a 35-page power of attorney? Well, you need that because in case I need to dig deep into the Florida rules, regulations, statutes, and Medicaid rules in order to get you qualified, I need special language in your power of attorney that authorizes your agent to do those things. So on a high level, you don't need to change them. However, it's always best practice because every state has its own bells and whistles. And I think it would be not your best move to leave intact something from another state.
And then kind of on that same note, how often would you recommend that a family get a revised POA, or like say if it's a 30-year-old document? I mean, is there a recommended increment of time to have those reviewed to, because the language could have changed? What should we tell families if they ask that?
Sure. So, once a document is validly executed, even if it's in the state of Florida, it's always grandfathered in and stays legitimate. It would be way too much of a burden for the legislature to say, okay, we're changing the power of attorney statute, and every Floridian that has a power of attorney must now go out and get it redrafted, or theirs is garbage. So that never happens. The old ones are always still good, but they are not as good as they could be as the statute changes and as things change. So what I tell people is, certainly when the statute changes, to give you an idea, the Florida power of attorney statute changed October of 2011. So if yours is older than October of 2011, highly recommend that you update it to the newer version. Also, my documents change from time to time because of case law decisions, Medicaid decisions, just best practices change over time. New strategies are developed that we need extra language. So for my clients, we have an ongoing relationship with our families. So I know every client in my database that, for instance, we've drafted a power of attorney for. When my documents, whether due to a statutory change or just the best practices, or I just enhance my documents further, we notify all of our clients, hey, there's a new version. We recommend that you get it. You're not required to, but here's what it does for you, and give them the option to come in and upgrade, keep them current. Obviously, if they've lost capacity from the last time we talked to them, they may be stuck with what they have, but we'd like to give everyone the opportunity. I think many attorneys miss that continuity of relationship. And a lot of them are kind of a one and done, where they draft your documents, you never hear from them again. And they're missing out on representing their client in a better way by keeping them current. And, you know, as a selfish business owner, I guess they're also losing out on revenue, because that's an opportunity to say, hey, the law changed. Here's my fee to upgrade your documents. Do you want to do it? And the light bulb is not on. They just keep trugging along and never even readdress their clients. So I think we give our clients better service by maintaining that relationship over time, and at least giving them the option and the education that there's an opportunity. If you want to, here, come in. And if you don't, at least you know you have the opportunity.
And one more, I just thought of something else when we were talking about COVID and how that's changed
Maybe
a lot.
lost your audio.
Oh, can you hear me?
You're muted.
Just muted me. Can you hear me now?
Nope, still don't have you.
Oh.
Can you hear me?
I can hear you.
Okay. Yeah, I don't know what happened to your
Okay, it just says unmuted. Okay, I don't know.
All right. So I think that is about it. I'll give you our contact information. If anybody has any questions, again, consultations are always free. We can do them over the phone. We can do them through Zoom, or you're welcome to come into our office, or even we can schedule to go out to wherever you're at, assuming that you're comfortable with that contact. So my website is www.mortellarolaw.com. You can also find us on the internet. The phone number, you can also find us on Facebook. The phone number is 813-367-1500. And if anyone has questions, please either reach out to Grace, and she has our contact info, or feel free to call us. For those of you that have not done a tour with Grace, I'm sure they have procedures now. They're probably doing virtual tours and things of that nature. So big point that I make to all of my clients is, you don't want to be looking for a senior community when your back's against the wall and you feel like you're stressed. You want to do that ahead of time. You want to have communities identified, when available, go in and have lunch and go tour the place, and just get an idea that if the day ever comes that we need this level of care, we've identified one or more communities that are good candidates. We already know their pricing structure. On a high level, we know if we can afford it. We know if we need to coordinate other benefits to afford it. Those are all important things. So I would recommend reach out to Grace and, again, have the conversation. There's nothing wrong with Grace saying, boy, you're too healthy to be at our facility right now, because the two constants in life is we're not getting younger and we're typically not getting healthier. So while today that community may not be what you need, it might be what you need tomorrow. And it would have been a good idea to have already vetted them, toured, understand the pricing structure, and be able to relay to your family of, hey, if I ever get to that point and I need this level of care, that's where I want you to take me. And that means you're still in control of your decisions before you need to make them. So on that, we will leave it. I appreciate the opportunity, Grace. Look forward to doing more of these with you. And post-COVID, we can do them in person with a live studio audience. They'll be more fun, maybe. I don't know. All right. Thank you so much. I appreciate the opportunity. If anyone has questions, please call us. Thank you so much. Have a great day.
Thank you. Bye-bye.